What happens if you have been working for your employer for a period of time and they haven't given you a contract or written terms of your employment? Well, in this situation, the prevailing law would apply. So that is in relation to things like a holiday and how holiday is dealt with. That's all set out in law. In relation to notice periods, again, that's set out in law. So in the absence of having anything in writing, then the legal position, the default position, will apply to you. There are other things that aren't covered by law, which would be covered by implied terms. So things like salary, for example. If your employer has agreed to pay you a salary and you've agreed to work hours in return and you've been doing that for a period of time, even though that's not written in a contract or terms and conditions, then that would be the salary that would apply to you by an implied contract. Oftentimes you will also find a number of your terms contained within the offer letter, so it's always worth checking that to see what that says, and also in any staff or employee handbook. Now, if you don't have a contract and you're worried about this, then it's always worth having a chat with your employer and asking them if they would provide you with one, if you feel that it would give you the certainty that you need, particularly if you're thinking about things like guaranteed hours or set rates of pay, those sorts of things where your pay may vary. So it's always worth asking. And if your employer isn't sure of their obligations, they can do a quick search on the .gov website where they'll find out that they have to provide set minimum terms under Section 1 of the Employment Rights Act.